on the ground that the CD was not admitted in evidence by the learned trial court. One. And despite the trial court rejecting by an interim application, the prosecution had requested the CD to be considered.
We are not inclined to re-hear the matter again.
But may I just, if your lordship permits, without not bothering your lordship with the evidence part, I'll just make about a few submissions, not requesting your lordship to not even touch the record for a minute. The only connection which has been established between the mobile phone through which allegedly the blackmailing calls were made is the statement of PW5 Murari. That was not referred to at that time. Your lordships have not been pleased to consider that argument because it was not argued. Now, except for the fact that Murari's mobile seems to have been snatched by the two accused persons and the blackmail calls were made by that mobile, there is nothing on record to connect the two applicants. One applicant has already been granted suspension by this honorable court exactly on the similar grounds. If I read about 27 memos also of both the applicants, they are just the same. Then except for not correcting that, now that mobile allegedly was snatched from the hands of Murari, and Murari makes a statement in 161 during prosecution that these two persons snatched the mobile, and after snatching the offense was committed. Now Murari in his court statements, I will not bother your lordship with the court statement, but suffice it to say, he says, I do not recognize both of them. I cannot distinguish between both of them. And yes, it is correct to state that these two persons did not snatch my mobile. These are not his categorical statements. Except not the seizure of mobile from these two applicants with similar 27 memos, except that following the 27 memos, the seizure of the SIM of Murari was at my instance. There is no distinguishing feature between me and the other person, Krishnapal Singh, was granted suspension. 27 memos prior to the seizure memo are exactly on the same lines, that we snatched the mobile and we made the calls. And the seizure memo says that the SIM was recovered at my instance, whereas the SIM obviously could not be recovered. So that is not an extremely weak piece of evidence to convict a man under 302. It was a blind murder. The blind murder again has no connection with the mobile. Now, during the time the mobile was snatched, a man was found dead, the case went on. Subsequently, allegedly a blackmail call was made by these two applicants to the brother of the deceased. In that mobile call, the only allegation is we said we will give you the same treatment which we give to your brother if you do not part with X amount of money. From there on, to replicate and to take that whose voice was there on the mobile, the entire prosecution replicated my voice. That CD was made. That CD was not permitted to be produced before the learned trial court. They dismissed the application of the prosecution. We will not permit this CD. So the CD is out. So there is no connecting of the voice. There is no connecting of the mobile also. Except Murari's statement, there is nothing in my learned friend. I'm open to correction by my learned friend. If there is any element, any connection which they can establish with the mobile phone between the applicants, the only connection with great respect, I'm repeating myself, was the statement of Murari. You could have said that yes, these are the two persons who snatched the mobiles and the mobile was then recovered from their position. And the SIM, the answer to the SIM being recovered at my possession is not true. One. No difference between Krishnapal Singh and Loken Singh, who's before my lord again. That to establish that there is a distinguishing feature. Two, it's an extremely weak piece of evidence wherein the SIM of Murari's phone was planted and shown to have been recovered from me by the prosecution. And not my suspension has been granted in blackmailing. The offense for which the mobile was used was blackmailing. I have been granted suspension by this honorable court on blackmailing case law. And in the murder case law, the prosecution with great respect is unable to establish anything to show that any act can be attributed for the commission of murder by this applicant. And if an act of murder, it's like this, two persons went on a bike, snatched, this is prosecution's case. Two persons went on a bike, snatched a mobile phone bearing SIM number 7220 ... and then committed a murder. No connection to the mobile, no connection to everything. In that murder, there is nothing. After the murder was committed, it was a blind murder, his body was recovered. And the cloth which was recovered, the trousers which were recovered not from me, are the same, the trousers were recovered at the instance of my co-accused also. And the trousers, my 27 Caesar memo of the trouser says कि खून जैसी कोई चीज नजर आई. Whereas in the co-accused recovery, it says खून लगा हुआ trouser recover हुआ है खून का. So except that, with great respect, I submitted. Murari's statement was not referred to, and I've spent 7 years inside, and that co-accused had only said, not that I am objecting to his being granted bail, I'm only trying to draw parity. I'm not happy with the suspension of the co-applicants, but I'm only not bothered about my own self that my 7 years have been spent inside. The entire case hinges on nothing else than the statement of Murari. If he would have stood the test of the prosecution case and said that yes, these are the two persons, you would have snatched them open. PW 5
Yes. क्या कहना?
In para 22, there is a voice recording CDR available in the record. And in para 20 of the PW 13, he has recovered the SIM bearing number 7220727. Since the trial court has appreciated the entire evidence by conducting the present application. There is an ample evidence available in the record and this has been appreciated by the trial court before convicting the present.
चलिए ठीक है. We'll pass you.
Good. But may I just make one second? If the trial court board has dealt with in any one paragraph the statement of Murari and said Murari's statements are against the prosecution case, but he's not even been declared a hostile witness. That's less. Grateful.
Sir. Yes. Sir.